154, People versus Ronel Joseph.
Good afternoon, Your Honors. Eunice Lee from the Office of the Appellate Defender for Ronel Joseph. I'd like to reserve 2 minutes for rebuttal.
You may.
Thank you.
Welcome.
Your Honors, the sidewalk basement of the deli should not have been deemed a dwelling where it was completely inaccessible, either externally or internally, from the apartments above the deli. At all times, Mr. Joseph could only be either underground in the basement or on a public sidewalk.
In light of
McCrae, how did the appellate division end up where it did?
Well, I mean...
That's a softball. I thought I'd toss it out to you.
That's a good question. Essentially, the appellate division read this court's decision in McCrae as being some type of per se rule that the only time that the exception applies is if the building at issue is large, and that's problematic.
Didn't McCrae refer to both remoteness and inaccessibility?
At various points in McCrae, it talks about both of those, but it's clear what it turns on is accessibility, because the concern is whether or not the entry, whether or not the burglary creates that likelihood for a special danger to the residents or confrontation.
Well, can't remoteness play on that too? Because if it's close, then that might create that kind of fear and reaction and whatever.
Absolutely, remoteness is relevant to the question of whether there is that possibility for confrontation.
And then isn't size relevant to remoteness?
Size and the nature of the building can both be relevant to remoteness. And first, I would say also that the building in this particular case, I would characterize as large itself. It's not a skyscraper, certainly. It's a 7-story block-long building. But aside from the question of the largeness of the building, it really does turn on accessibility. Here, there's no access at all to the apartments, internally, externally.
Well, it's a little unclear. Where is the actual entrance to this building, vis-a-vis this deli?
The prosecution put forth no evidence with regard to the...
We don't know where the entrance is? The photos shed no light on where the entrance is of the building itself, the residential part of this building?
There's no evidence in the record of that. There's a picture introduced that shows the front of the deli and the cellar doors into the basement, but there was no either testimony or evidence introduced about the entrance to the apartment buildings.
So if part of the building, you agree that part of the building is a dwelling?
That's correct.
There's no doubt, right, in your mind?
That's correct.
Okay. And you agree that the basement is part of this building? Yeah?
Well, it's...
Or you don't think it has a separate address or a block number or something like that, right?
The basement does not have a separate address from the deli, but there's no evidence that the basement of the deli is connected to anything else, any other part of the apartment buildings.
So are you suggesting that there's not proof that the basement is actually part of the building that's a dwelling?
Well, that's not really, I guess that's not really sort of the point of contention. The point is that because there's a complete lack of access here between the basement and the deli, this is the type of situation that this court in McCrae acknowledges, one where there's not that special risk to the residents of the apartment building.
See, you seem to be minimizing proximity in favor of accessibility, and the reason I bring it up is, I guess, McCrae, I think of hotels, and in hotels, you may not be, a hotel room may not be accessible, but certainly the kind of danger that's talked about is created by the proximity of a burglar going from room to room, and it's really a two-pronged test, and I think you have to address both.
Well, I mean, proximity absolutely matters, but proximity in the absence of access, I mean, the fact that an offense can occur near someone's residence is not something that makes it appropriate to consider it a burglary of a dwelling if there's no access to the residence, if there's no special position that the residence...
Suppose instead of going in, because this, as I understand it, the doors are those sidewalk doors that open so they can put...
Correct. It's
stuff in. Suppose instead of that, he had walked into the deli.
Well,
Would that be a burglary of a dwelling?
Assuming that it did not occur during, again, this was business hours when this particular case happened, but had he gone into had this been a break-in or a nighttime entry into the deli?
No, I'm just saying, the same time that this happened, I think it was during the day, I don't know, but
Well, there'd be different issues in terms of whether or not it was a trespass, since it was a business and it was
Well,
open hours, but
Wouldn't your argument be the same? It's not a dwelling. I mean, right?
frankly, the lack of internal, external access to the deli, there is certainly a reasonable argument as well that that is not a dwelling. That might present a closer case, because in that context, you do at least have the nature, the shared nature of the walls, the sort of the closer context.
No, but my
presents a-
point is, aren't there degrees of burglary that make a distinction between a building and a dwelling?
Oh, I'm sorry, yes, that would be third-degree burglary,
So
not
going
second-degree.
into the deli would be burglary of a building, right?
Correct.
I'm trying to figure out how, if that's not a dwelling, the basement where they store their inventory that has no other access other than from the sidewalk.
Well, my adversary's argument would be that that is a dwelling, that the fact of this commercial space being underneath apartment buildings, that is, regardless of access, that is enough to make a burglary of the deli a burglary of a dwelling, and I obviously dispute that
Ms. Lee,
position.
does the nature of the use of that basement or the character of the contents that are stored in there, does that change the analysis? If that was space designated for the tenants to keep their kids' bicycles or whatever?
That would certainly, I mean, if that were the case, that would be a factor that the court could consider, because again, the question is, what is the possibility of there being either a confrontation or a special danger to the residents? And so if this was part of this, if this basement were the residents' basement and they had cause, or could perhaps have cause to be there, that would present a different case than this, where it is commercial space, solely belongs to the deli, used as storage, and it's
Does
essentially
that go
sort
to the
of...
knowledge of the defendant,
I'm sorry, Your
to
Honor.
the knowledge of the
It's
burglar?
not, it's not really about, the knowledge, it doesn't turn necessarily on the knowledge of the person going into this space. It's again, sort of, what's the danger being created here?
Could
And
I
so-
go back to what you said about remoteness and accessibility? And are you saying that there have to be both prongs or only one prong?
Well,
of the test?
what I'm suggesting is, the reason remoteness matters is because of accessibility. The purpose of the statute is to avoid these confrontations, and so to the extent that a location that's being burglarized is extremely remote from the dwelling, then that means that there is a lesser likelihood of accessibility.
So even if in the, I think the example that Judge Rivera was trying to bring up, although we have nothing in the record, hypothetically, if the cellar were right next to the entrance to the apartment building, would you say that that wasn't proximate enough, or it's not remote enough, or it is too remote?
I think the problem is it can never be solely a question of remoteness. Access has to be considered combined with that, and so even where it's a close location, where there's no access and the only confrontation that could occur is on a public sidewalk, that takes it out of the realm of being the burglary of a dwelling.
Thank you, Ms. Lee.
Can I,
Counsel?
Judge, would it be all right if I
Yes.
just ask one question? Just, I didn't want to miss you on this. The CJI has a slightly different standard that's referenced. I think they refer to the nature and the size of the building, rather than just a large. Do you want to address that for 1 second?
Correct. Yes, the CGI, the current version, which was revised specifically to reflect this court's decision in McRae, includes language saying basically that in determining whether or not it should be considered a dwelling, that the jury, it's appropriate to consider the nature and the size of the building as well. And I think it also includes language as to whether or not there is a possibility of this, again, confrontation or interaction with residents in the building.
Thank you. Counsel?
May it please the court, Diane Prince on behalf of the people, the respondent. Your Honors, defendant's conviction...
Counsel, can I'm sorry to interrupt you, but it seems to me you fall within the statute, this is a dwelling, right? Four corners dwelling. So the issue here is, does this fall within the exception to that rule? And that, to me, is remoteness and accessibility. And I think we can agree here, this isn't accessible. I mean, it's a sub-basement of a deli, which itself isn't connected to the residences, right?
Yes.
So it really turns, it seems to me, on remoteness. And if you look back at the old Quinn case, they talk about large, and I think you argue that in your papers, but what's the relationship between large and remote? Because I think large is a bit of a misreading of Quinn.
Well, first, Your Honor, I would say that Quinn actually says large itself when defining this exception. It begins by saying to ward off apprehension, a different rule
Right, but I
comes in.
think if you read Quinn, it's 1878, right? And that building is, somebody who owns the business lives there. And the fear is, even though it's not connected, you are going to hear this noise and you're going to respond, and that can lead to injury. So it's in that context, I think they're using large, which is really large more than a physical sense. It's large enough so you don't have that type of relationship, it seems to me. So it's really remoteness, a better way, and I think our more recent articulation of it. So it's remoteness. So why isn't this building, where you've got a sub-basement of a deli that itself isn't connected to residences, remote?
Well, to go back, Your Honors, as you were describing the facts of the case with my adversary, this is one story removed from where the residents begin. It's not so remote that it's, as the court in McRae explained, that there's virtually no risk that the
Well, what if it
residents...
was in the building that was immediately adjacent to this building, assuming that there is one? That would be also pretty close in proximity, but would that be enough?
No, but that wouldn't be the same building. We have to take a step back. The statute in this case is this...
Well, is the defense correct that there's not evidence in the record about where the actual entrance to the residential part of the building is located?
That is correct, Your Honor.
Okay. Did you put in any evidence about access from the deli to the residences?
What is in the record is that there's only one entrance to the public to the deli, and that's the front entrance, and you can see a photograph of that.
Same thing to
in
the
record.
basement, right? You got to go through those doors that are flush to the ground.
Yes, Your Honor.
So how would he, in your argument, let's say it's not, let's say there's not a distance, right? You don't have the remoteness problem. How would he have gained access to the residences?
Well, he was in close physical proximity, and
I
I don't think...
understand. How is he going to gain access to the residences? He's in this basement. And you could see the basement doesn't connect anyway to the there's only one, right? Entrance and exit from the basement.
Yes,
Okay, so how is he going to get to the residences?
I'm sorry, he would have to break through. But I want
And
to...
then do what, since you didn't put in evidence about where the entrance to the residences are?
He would have to climb up, but we're talking about hypotheticals, and I asked this court to... We have always argued that the statute is clear. It says that if you break into a building containing dwellings, that is the burglary of the dwelling. We are talking about an exception to this rule, which this court has defined narrowly, and I have to point out, this court in McRae repeatedly said large, and that term has a meaning.
No, it doesn't, because the reason we did that is you're in a big hotel, and the question was, you know, when this person's wandering around hitting all of these places that really were serving the hotel. I mean, that was their customers and things like that. It was almost fortuitous that it was as big as it was. But what we were concerned about and what we debated so often was that there was certain ways that you could get from these shops to the rooms where the people were, but then distance, you know, and the size made it more a dwelling than just being able to access it. Here, you've got a situation where, in fact, in capturing this guy, you just closed the doors. He couldn't go anywhere. He couldn't go to the deli. He couldn't go to the, pardon me, the dwellings, which is where people sleep at night. And so I don't see how that could possibly be a dwelling. If it is, you know, if you've got a bank in an apartment building, if you got anything in an apartment building, those are all dwellings. The dry cleaners on the first floor of an apartment building is a dwelling, right?
Yes, but that's what this court announced in Quinn. This court has...
Quinn was 150 years ago.
But the court in McRae reaffirmed that ruling. The crime is designed to deter the violence that, as this court has said,
But
is
the question
inherent.
is, you're right about the crime, but the question is whether or not the large standard is applicable, or whether it's so inherently subjective that to rely on it and not to grant the exception on the basis of that is it's impossible to reconcile with the geography of the entire state. Large in Auburn, New York, a building that's large in Auburn, New York is not the same as a building that's large in Manhattan. Those are two different kinds of things, and the rules that we make have to apply to everybody. And the purely subjective nature of that, in refusing to apply that exception in this particular circumstance, given the clear lack of accessibility, makes your case more difficult.
I would say, Your Honor, this court used the term large. It explained, you can look at the facts of the case, it defined that
So
building
let's
as
assume you've got a
large.
building, this seems to be getting more and more common. You have a brand-new office building that's set up, and as part of the office building, there's a hotel.
Yes.
Every office in that building is now a dwelling.
Yes, Your Honor. The statute, I'm sorry if I'm repeating myself, the statute
Please
is
do.
clear. And the court has carved out, the court has recognized a narrow exception to that statute. And what I'm asking this court not to narrow.
What is a
sorry.
building? I mean, you're making every business in the city of New York, I guess, and probably a lot of upstate, that even hints at having a hotel or any type of thing like that, a dwelling, even if it's mainly an office building.
That's what the legislature intended. That's what the statute says. It says if it's separately occupied, it's itself a building, but it's also a part of the main building. What I'm saying is the statute has broad range.
So we have the exceptions to this mixed-use complex.
Exactly.
All right, so what's the evidence that the people put in about the size, since you seem to depend on the size of this building?
Well, it's a 7-story residential apartment building. All 6 stories above the store were residential apartment buildings. And that this
That's
building,
not telling me about the size, other than, sort of the...
you know, it's a 7-story apartment.
Yes, but some buildings are an entire block.
Well, there's a photograph
Some
in
buildings
the
are very
record.
small. I looked at the photograph, that's why I'm asking the question.
Well,
Was
it's not
was
an
that all the
entire
evidence, by
block.
the way? Is that just the photos?
We had the photos and the testimony from the police officer who explained that it was a residential apartment building. All 6 floors above contain residential.
So we don't really know how big the building is.
We don't
reality.
know feet-wise, but we can picture, it's not an entire block. It's a deli, and I think from the photograph, it's reasonable to infer that it's no bigger than this room.
Well, counsel, even if we were to agree that we did use the term large in McCrae and in Quinn, because we took the language from Quinn, but we also said in McCrae that in large buildings, situations can arise in which the general rule will not be applied because it does not make sense. So even if we did, even if this were not a large building, and it may not be by some standards, aren't we really trying to figure out what makes sense? And does it make sense to say that a cellar that is inaccessible other than through 2 doors on a sidewalk that can be locked and contain the alleged burglar, does it make sense to say that that's a dwelling?
Yes, Your Honor, I think it does. And I will point out where Your Honor was quoting, that's the court discussing the policy behind this narrow exception. And the court ends by once again noting in large buildings situations. So what I'm asking this court is please do not read out the largeness requirement. Please do not expand this exception, especially when the statute is so clear on its terms.
Is there a difference between large and remote? Or is large a factor in considering remoteness?
Yes, Your Honor, and I think remoteness explains the largeness. It's not just, there's 2 requirements here. It's that you're so far removed because of the largeness or the size of the building, there's great distance, and not only that, you lack access. That's when the exception applies, not in this case. This case, sorry.
When I looked at the pictures, you've got this deli, but down the street, it looked like on the first floor of every single building, there was a business.
Yes,
And every single one of them is an apartment house.
exactly, Your Honor.
So everybody, I mean, if you go in to rob the bank, you've committed burglary of a dwelling.
Well, I don't think that's unfair because you have notice. The point
No, your
of-
answer is yes. I mean,
Yes.
that there is no way that you can burgle a building in the city of New York as long as they're an apartment
And
building.
you shouldn't. You should be on notice that this is where, I'm sorry, my time is out, I'm just going to, the statute has a broad application to deter this type of behavior. You should not enter a building where people live. People in this building are entitled to feel safe at night. Thank you, Your Honor.
Ms. Lee, if the building is predominantly residential, why does it matter that there is no internal communication there? I'm not following.
Well, again, I mean, I think part of what the court highlighted in McCrae, in addition to the language about it being large, what the other formulation was that it shouldn't be deemed the burglary of a dwelling where the intruder, neither comes nor readily can come near to anyone's living
Building's
quarters.
predominantly residential.
Right, but he can't, from this basement, which is not accessible to the deli and not accessible to the apartment buildings, cannot readily come within context of someone's living quarters. It's just not possible. I mean, to the extent that McCrae is saying we have to consider whether or not there's this possibility for confrontation or special danger to the residents, it has to be about access.
I disagree with that, because, yeah, it's partially about access. And if you have access, I think generally you're going to lose, although, on your argument, although McCrae left that open, right, in terms of it could be large enough that even if you had access, I think the language was this is a very close case, because it was a hotel. But if you have access, I think you lose, unless it's, the Hilton. So then you have to go to remoteness. So your argument, it seems to me, really hinges on, to get back to, I think, what Judge Stein and I were asking about earlier, is remoteness versus largeness, right? Is this just how many stories, or is it a block, is it half a block, or is it something else? And to me, it seems like there's a something else there, going back to some of these factors you were talking about, especially the 1878 case, that there's a family-owned business and they're sleeping next door, although they didn't have access. So access alone, I mean, Quinn, they didn't have access, and it was still a burglary. So that isn't the determinative. But what is remote? How are we to define remote? I mean, again, getting back to large in different parts of the state will mean very different things. So how do we define remote?
Right. Remote certainly can't be defined solely as a matter of what is the size of the building. It has to be looked at in the context of the location that's being burglarized and its connection to the apartments. Because again, what the court's looking for is what is the likelihood that this is the scenario that's going to create that kind of confrontation with the residents that we're concerned about. We're here where this basement, it's not connected to the apartments. There's no, both not connected physically or in any other way to the residents. This fits that category of this is not what the burglary statute is about. And it's hard to imagine, I mean, if it's all of just...
Wouldn't it be relevant, again, and it appears maybe we don't have the information that we need here, but wouldn't it be relevant if one of the residents is going to his or her apartment and the door to access that apartment is within feet of the door down to the cellar?
That would present a closer case, but I think the other problem still, even with that scenario...
Oh, wait, how is that? Isn't the person still outside on the public street?
Well, that's what I was going to say. The problem with that analogy is that in any interaction that anyone could have with Mr. Joseph would be on a public sidewalk. And so the fact that the public sidewalk is near someone's front door, that's, it's not a trespass and it doesn't convert it into a burglary. And so the concern about confrontation obviously might be greater, but where the residents of the building are indistinguishable from a passer...
So we have a public access exception?
Well, it's not about public access, but it's, again, burglary is about trespass. And the fact that I'm walking down the street and I live in this building and I see a burglar, you're walking down the street and you see a burglar as well, it's still not a burglary of a dwelling. My status as a resident, when I'm walking down the street, is indistinguishable from a passerby, and that's not what the burglary statute is intended to address.
Thank you.
Thank you.